Did you know that you can travel on advance parole with your TPS, and you may have a lawful entry, and then you may adjust in the United States under an employment-based petition that has been approved? We're going to talk about this. I'll give you all the details. And hey, those of you who are new to the channel, my name is Humberto R. Gray, and you can get me at hrg@graylaw.com. We got a lot of good news updates today as well, and we're going to talk about some really interesting cases. So hey, a lot to get to. Let's jump right in. Let's get at it. All right. I just got a case approved without an interview. This is great stuff, folks. So I had a client. We filed a labor certification. It was approved. We filed the I-140. It was approved. That client was in TPS status, and back in 2014, he traveled out of the country on advance parole, re-entered the country. Otherwise, he was out of status before he filed for TPS, right? There is a Supreme Court case, Sanchez, that came down August of 2020. And the law prior to Sanchez was, if you travel on advance parole and re-enter the United States, you are in legal status and you can adjust under 245A. So those individuals in the United States who traveled before August 20th on advance parole, TPS, re-entered the United States, guess what? You are legal and you can adjust under an employment-based visa. A lot of people don't know this, folks. So the basic rule is either DACA or TPS. If you travel out of the U.S., you come back on advance parole. If you marry a U.S. citizen, no problem, legal entry, you can always adjust. But under an employment-based visa, different story. So you got to check your dates. If you're on TPS and you travel before August 20th, you are considered in status in the United States. All right, I got another bit of good news. So in some of my previous videos, I told you that I had a client who was denied at the U.S. consulate of her H1B based on C6, which is fraud. So the facts of this case involve her applying for an H1B with a company that was engaged in fraudulent conduct. My client was the victim. This company, what they would do is they would make you work long hours and promise that they would pay you. They never paid her. A lot of other victims was caught up in the scandal. And what happened was immigration alleged that anyone working with that company was engaged in fraudulent conduct. So they imputed the fraud from the company to the individual client. So what we did was we sued immigration, and we just recently won. We got the fraud C6 removed from the case, and now my client is eligible to receive her H1B, come back and resume work in the United States. So a lot of times you can sue the government under the Administrative Procedure Act, and it's a great tool to get immigration to change decisions when they're making incorrect decisions. Generally, decisions of U.S. consulate, non-reviewable. It's called the NonReviewability doctrine, but there are certain times where USCIS makes a decision now that's considered USCIS. It's not State Department. You can sue under the APA. By the way, there's a new case that's coming through that would suggest even State Department, the decisions are not non-reviewable. So we're going to keep you up to date on that. That's going to be a really good decision. All right, let's talk a little bit about the medical exam. I put a link in the description box. I put a flyer here as well. Everything about the medical exam, right? So first, it's good to know that when you're in the U.S. and you're filing an adjustment of status, you have to have a medical exam that is approved by the civil surgeon in the U.S. There's only a few doctors that are on immigration's list. You go to USCIS, find my doctor. You can find the doctor that's closest to you. You get the medical exam, the doctor will seal it. It cannot be opened until it gets to USCIS. Medical exams after November of 2023, this is great news. They do not expire. So once you take that exam, you're good to go. You put it in your adjustment of status package and send it off. Now, do you need to get the medical exam in the U.S. if you're picking up your green card overseas at State Department? The answer is no. You do not need to get the medical exam in the U.S. There are doctors in State Department, so you're going to get the medical exam overseas at a physician that's near your U.S. consulate abroad. Okay. All right. What about vaccinations? COVID-19? I put a link in the description box here. So good news is that for travelers in general, the COVID-19 vaccination is going to be lifted. However, for green cards, you still need the vaccination, both State Department and in the US, okay? All right, one last bit of good news, biometrics. We've talked about this, folks. We've had problems with scheduling. USCIS is rolling out a new tool that you can use to reschedule your own biometrics appointment as opposed to calling the contact center. You can do it yourself now. This is great news. They're rolling it out. There's a 60-day comment. So 60 days from now, when it's actually rolled out, I'm going to give you the link and get you updated on how you can reschedule your own biometrics appointment. Hey, YouTube family and GN subs, thanks so much for watching GrayLaw TV. Click below, like, and subscribe. Go to my content, folks. Some really good stuff here. You can learn immigration from my content for free. Really good stuff. And hey, we'll see you next time.